Good afternoon, everyone. I'm Lisa Baldez. I'm an Associate Professor of Government and Latin American, Latino, and Caribbean Studies, and I'm very pleased to have the honor of welcoming our guest today. And I'd like to thank you, the hard New England core, to brave the elements to come out here today. I really am happy to see you all here. I wanted to start off by noting that this is the Timbers Lecture. This lecture is named for William H. Timbers, class of 1937. In May 1995, a Dartmouth endowment fund was set up for Mr. Timbers and the Honorable William H. Timbers by the legal firm of Skadden Arps, Slate, Meagher, and Floam, for whom Timbers once practiced. Judge Timbers was an esteemed lawyer and judge of U.S. District Court for Connecticut, 1960, and judge of U.S. Court of Appeals for the Second Circuit in 1971 to 1981. The fund is used to support activities related to the study of law and justice within the Faculty of Arts and Sciences, and it also supports visiting speakers, discussions, and conferences on topics relating to the law. This talk is also sponsored, obviously, by the Rockefeller Center, but it's part of what's called the Dartmouth Centers Forum, which is a coalition of all the centers around campus around a particular theme. This year's theme is words and their consequences. And the language for this theme, words and their consequences, has kind of an underlying tone that words can be used to hurt. Words can be used for have painful consequences, such as hate speech or aggressive speech and the regulation of issues regarding hate speech, the weaponizing of language. But I'm very pleased that today we're going to be talking about an example in which international law, in which words and not sticks and stones, and not in various concrete enforcement mechanisms, have had a very important and positive effect, which makes it even more puzzling that the United States and its relationship to international law is often quite confusing, very challenging. Professor Hathaway is going to talk to us about some of the conditions under which international law is brought to bear in the U.S. political system. Our speaker today, Una A. Hathaway, is the Gerard and Bernice Latrobe Smith Professor of International Law at the Yale Law School. She earned her B.A. summa cum laude at Harvard University and her J.D. at Yale Law School, where she was editor-in-chief of the Yale Law Journal. She's had an impressive professional career. She began as a law clerk for Justice Sandra Day O'Connor, and she worked for D.C. Circuit Court. She clerked for D.C. Circuit Court Judge Patricia Wald, very famous and well-known human rights lawyer. She held fellowships at Harvard University's Carr Center for Human Rights Policy and the Center for the Ethics in the Profession. She's served as an associate professor at Boston University School of Law, associate professor of Yale Law School, and professor of law at UC Berkeley. Her current research focuses on the intersection of U.S. constitutional law and international law, the enforcement of domestic and international law, and the law of war. Professor Hathaway received the Carnegie Scholars Award in 2004, and she's professor by courtesy of the Yale Department of Political Science. Woo-hoo. She's also professor of international law and area studies at the Yale University Macmillan Center. She's on the executive committee of the Macmillan Center at Yale. She serves as a member of the Advisory Committee on International Law for the Legal Advisor at the United States Department of State. She's testified before Congress several times on legal issues surrounding the U.S. war in Iraq, and she consults regularly with the Senate Foreign Relations Committee on current issues of constitutional and international law. I'm very pleased that you're able to join us today, and I'm very pleased to have with us Professor Una Hathaway. Please join me in welcoming her.
Thank you so much, and I already got my first present, so I appreciate that. Well, thank you all. You're such a hearty crowd to come out in this weather. It's great to be here. I really appreciate the chance to speak with you all today, and I'm thrilled to be the William H. Timbers Distinguished Lecturer for 2012. Now, you mentioned that he was a judge, but you left out the most important biographical fact, which is he went to Yale Law School, which was my own alma mater and where I also now currently teach. So I have a special affection for him, not only because he's funding this lecture or it's in his name, but also because of this connection. So the subject of my talk today grows out of a project I've been working on now for about 4 years on how the United States makes its international law. And this has resulted in a couple of articles. I'm currently working on a book, so this is an ongoing project of interest for me, and you'll see several aspects of this have unfolded over the course of the years. I'm very excited to hear your feedback on it because it is an ongoing project, and I'm going to try to not speak for the full hour. I was asked to speak for an hour. I thought you all would probably not want to listen to me talk at you for an hour, so I'm going to keep it shorter than that. And so I'm excited to have some exchange and hear your questions and thoughts about the project. So I want to make a two-step argument today. First, I want to argue for holding international law to the same standards that we hold domestic law. Like domestic law, international law must meet basic standards of accountability and democratic legitimacy. Thus far, relatively few have held international law up to light in this way, have held it to this kind of standard. And I want to do that today. I want to hold it up. I want to examine it this way and begin to look at both what its strengths are and where it tends to fall short. Second, I want to think about solutions. I want to say that the argument that the solution to democratic shortcomings in international law is normalization of international law, so what I'm going to call normalization. We should bring international law within the familiar structures of domestic law. This will significantly address many of the concerns that I'm going to raise about the democratic legitimacy of international law. And in the process, I argue it also strengthen international law, make it easier to enforce international law in the courts. So let me begin with the first part, the argument about holding international law to the same standards that we hold our domestic law, to the same standards of accountability and democratic legitimacy. So I want to start by telling you a little bit of what I mean when I say international lawmaking, because it's not necessarily transparent. I'm talking about the process by which the United States makes its international agreements. So how does it commit to international treaties? And now international law leaves it to every state to decide for itself how it's going to sign on to international agreements. Under the Vienna Convention on Law of Treaties, any written agreement between two states is a treaty. And how the state decides to sign on to that is entirely up to the states themselves. So every state designs its own structure, its own mechanism. And what I'm going to talk about today is the U.S. system. I'm happy to talk about comparative aspects, and I'm going to raise a few things that show that we're quite strange in the way that we make our international law, that the structures and mechanisms we use are very different. My central focus is on how the U.S. does that and how that's structured through our constitutional system. So there are 4 different ways in which the U.S. makes international agreements. I'm going to talk about each of them briefly. First, Article 2 treaties. Second, sole executive agreements. Third, congressional executive agreements. And among these, there are 2 different kinds. One is ex ante congressional executive agreements, and another is ex post congressional executive agreements. So I'm going to talk about each of them briefly. I'll tell you a little bit about what they are and what I think their shortcomings are. Now, I'll just preview for you that I think the first 3 of these all have significant shortcomings. There are significant problems of democratic legitimacy and accountability. Only the last, the ex post congressional executive agreements, do I think really live up to the standards that we ought to hold our international lawmaking. Okay, so first let me start with what's probably the most familiar to all of you, what you've probably heard of and thought of when you think of international law or international treaties, and that's Article 2 treaties. Now they're named Article 2 treaties because the treaty clause is in Article 2 of the U.S. Constitution. These are the only agreements that are this is the only process explicitly mentioned in the U.S. Constitution. This is a process that says that the president shall, with the advice and consent of 2/3 of the Senate, make international agreements. This is being used, for instance, to conclude the Convention Against Torture, the UN Framework Convention on Climate Change, extradition agreements, and bilateral investment treaties. Now, there are, in my view, 2 key democratic deficits with the Article 2 process. So first of all, it completely excludes the House of Representatives. The House of Representatives has nothing whatsoever to do with Article 2 treaties. They're not mentioned, they're not included, they don't have to sign off on it, they have no role whatsoever in making Article 2 treaties. And we usually think of the House of Representatives as the most representative part of the federal government. So why in the world would the authors of the Constitution have excluded them from the process of making Article 2 treaties? Well, there were actually 2 good reasons at the time, or at least what they thought were good reasons at the time. So first, the Senate was expected to serve as a council of advisors. So they imagined that the Senate was going to be this illustrious body of advisors. There were going to be 2 from each state, so there'd be a group of 26. They had in their mind that they would actually get together and talk with the president about international treaties. They would advise him. The advice part of advice and consent was meaningful. They would actually advise him about what the terms of the treaty ought to be, that they would sit in the room with him and talk it through. And second, they were concerned about secrecy. They trusted this group of 26 senators who were going to be, as you probably know, indirectly elected through the Senate, through the state legislatures, and so insulated from the kind of immediacy of democratic politics. Much more than they respected and expected the House of Representatives, which had an unruly large number of 65 members at the time, to be able to keep a secret. Well, so very quickly, both of these justifications were undermined. So in 1789, President George Washington made the first and last visit by a president to the Senate to consult about a treaty. He went to consult about a proposed treaty with the Southern Indians, and he sat, and he sat, and he waited, and he sat, and then he went into the room, and it was incredibly frustrating. They wanted to talk about every little minutia. They argued about it endlessly. Hardly anybody could hear one another with the carriages going by. And he was so frustrated by the experience that he declared it, quote, defeats every purpose of my coming here, and never again appeared in person to discuss a treaty with the Senate again. By the end of his presidency, advice and consent had turned into simply consent. So this idea that there would be a council of advisors very quickly went out the window. Well, that will not surprise many of you here. The Senate also proved incapable of keeping a secret. The 1795 Jay Treaty with Great Britain was leaked to a local newspaper, creating a huge uproar, despite the fact that there was an agreement between the Senate and the president to keep it a secret, and they knew it was going to create a huge uproar. So Washington declared the Senate was, quote, not a safe repository for diplomatic secrets, and decided that he was not going to tell them about any treaties if he could help it. So the Article 2 process excludes the House of Representatives for 2 reasons that within a decade were proven to be not particularly well-justified reasons. And including an important part of the legislature from the process of making international law, we stand close to alone in the world. In particular, only the United States, Mexico, and Tajikistan cut part of the legislature out of the treaty-making process and then make the results of that treaty-making process automatically enforceable in their courts. So directly enforceable in their courts, despite the fact that a significant part of the legislature has been excluded from the process of making those international agreements. So, and excluding the House of Representatives is particularly problematic in the modern era, I argue, because international law and domestic law are a lot harder to distinguish today than they were at the time of George Washington. International law today is not just about border disputes and diplomatic relations. Today it's about everything from education to tax policy to torture. And so excluding the House is increasingly problematic. Now, the second shortcoming of the Article 2 process is it requires a 67-vote majority in the Senate. So it excludes the House altogether, and it creates this incredibly high bar in the Senate. In order to get the consent of the Senate, you have to have 67 senators vote in favor of that. Now, the supermajority requirement prevents the federal government from concluding treaties that are disfavored by a minority, and that was part of the reason it was designed that way. And in fact, the founders had in mind at the time a particular treaty. Spain had proposed a treaty exchanging 25 years of navigation rights on the Mississippi River in exchange for special trade access. The northern states were excited about this because they had the industry. They were most likely to benefit from the trade agreement. The southern states vigorously opposed it because they worried that it was going to upset the balance between slaveholding states and non-slaveholding states. At the time, the North had a bare majority over the South. They wanted people to be able to come in through the Mississippi River, immigration to come in, slaves to come in, and goods to be able to be brought in and out. And they vigorously opposed it. They were able to narrowly defeat that proposed treaty, which was proposed under the Articles of Confederation, because the Articles of Confederation required that 2/3 of the states approve any international agreement. So the southern states insisted that the new Constitution have a similar bar in it, that it have this 2/3 majority requirement. And in fact, James Madison wrote a letter to George Washington in which he said, I am entirely convinced that unless the project to yield the exclusion of the Mississippi for 25 years be abandoned by Congress, the hopes of carrying the state of Virginia into a proper federal system will be demolished. So it was clear that the stakes of this were extraordinarily high. And it was essential to many of the southern states being willing to sign on to the Constitution as it was, that there be this 2/3 bar. Now, it was an essential compromise at the time of the founding. But today, with our malportioned Senate, this 67-vote majority has the perverse effect of allowing senators that represent just 8% of the country to veto a treaty. This means that the polarized extremes of modern American politics can prevent the passage of a treaty. So I arrayed all the senators on a measure of ideology commonly used in political science. And I arrayed them from most liberal to most conservative, and then looked to see what's the relationship, how conservative or more liberal does this 2/3 bar mean the person has a veto over it. And the 67th senator was just over twice as conservative as the 51st senator. And in the reverse dimension, the 67th senator was about twice as liberal as the 51st senator. So you have to really play to the ideological extremes, because these ideological extremes have a veto over Article 2 treaties. Now, there are times when a supermajority requirement like this makes sense. So supermajority requirements appear in the Constitution in other contexts for things like impeachment of the president, override of a presidential veto, amending the Constitution, removal of the president from office for inability to discharge the powers and duties of the office. In those cases, the supermajority requirement makes sense because the cost of incorrect decision-making is immense. But in this context, the cost of incorrect decision-making isn't, at least today, nearly as strong, because a treaty can be undone by subsequent legislation. So it's not locked in time for all times. A subsequent law can undo it, and even most people believe that the president can unilaterally undo an Article 2 treaty all by himself. So that argument does not hold. But the costs of this threshold are incredibly high. It means that many treaties that might have been made will not be made. And it means a lot less international cooperation that serves really important interests happen, like the CEDAW Treaty, which we were talking about at lunch today. So we've seen this, for instance, in the fight of the Law of the Sea Convention. I don't know if you all have heard this. It kind of comes up periodically. President George Bush was the last one to wage a fight for the Law of the Sea Convention. Not generally known as the strongest proponent of international law, but he pushed really hard to try and get the treaty ratified. But he wasn't able to get it ratified, even though he had strong support from the military and from prominent members of the Reagan administration. Even John Bolton supported the treaty. This is the same John Bolton who famously said there's no such thing as the United Nations. If the UN Secretary building in New York lost 10 stories, it wouldn't make a bit of a difference. He supported the Law of the Sea Convention, but even his support wasn't enough to get the 67 votes needed to pass that convention. So in sum, this Article 2 process falls short in an assessment of its democratic accountability, both because it excludes the more representative House of Representatives and because it requires a threshold in the Senate that gives a veto to the national ideological extremes. Okay, so that's the first. Now the second type of international lawmaking. Second is what we call sole executive agreements. Sole executive agreements are kind of like what they sound like. They're made by the president by himself using his own constitutional powers. Now, to the extent that sole executive agreements operate within their legal confines, that is, within the president's own clear constitutional powers to act by himself, there's nothing particularly wrong with them, in my view. But the reality reveals something quite different. So first, sole executive agreements are concluded by the president through a process that's entirely shielded from public view. So if you haven't heard about them, you're not alone. There are a lot of people who haven't heard about them, and that's because they are not made public. They're not published, they're not talked about. They don't have to be made public. They don't even have to be disclosed to Congress until 60 days after they've gone into effect. And so at that point, the Congress faces a fait accompli. It's already in effect. This agreement is international law, and there's nothing to do about that other than to pass a law undoing it, which of course then is subject to a potential presidential veto, which you would require a 2/3 majority in both houses to overcome. So this process is open to abuse by the president, by presidents who use the process to conclude agreements that actually go beyond their own constitutional power and therefore beyond what legally should be the limits on sole executive agreements. We saw a good example of this a few years ago when President Bush concluded a bilateral agreement with Iraq. After the UN mandates expired, you may recall that President Bush entered into a bilateral agreement to continue U.S. troop presence in Iraq for a period of 3 years and agreed to certain kinds of terms related to that ongoing troop presence in Iraq. That was never brought before Congress. So the president decided to conclude this all by himself, despite the fact that there was a great deal of upset and uproar in Congress. This announcement was subject to criticism by Senator Hillary Clinton, who introduced a bill that would have prevented funds from being used to carry out any bilateral agreement between the United States and Iraq involving commitments or risks affecting the nation as a whole unless approved by Congress. Senator Barack Obama signed on as a co-sponsor. Senator Joseph Biden submitted a similar bill of his own. But despite all of that, the president forged ahead. He concluded the agreement. It went into effect on January 1st, 2009, just a few weeks before President Obama took office. During that debate, the administration not only refused to submit the agreement to Congress for approval, as everyone was requesting, but refused even to release the draft of the agreement. So members of Congress and those of us called to testify about this agreement before the Congress were reduced to reading translations of a leaked draft that had been leaked in Arabic to the Arabic press and then translated into English. And then all of us were trying to make sense of this garbled English draft. So to add insult to injury, the Iraqi government insisted on submitting the agreement to their own parliament for approval, even as our own refused to do so. So the problem with sole executive agreements is not necessarily that they allow the president to conclude agreements on his own within the scope of his constitutional authority. I don't mind those agreements. I don't think those are particularly problematic because those are things the president could do by himself anyway. But it's that there's no transparency, there's no monitoring to ensure that agreements actually stay within these bounds. Okay, third, ex-ante congressional executive agreements. So I told you there are two kinds of congressional executive agreements. The first one is ex-ante congressional executive agreements. These are created when Congress grants authority to the president to conclude an international agreement. So when Congress grants authority beforehand, so that's why ex-ante as opposed to ex-post. The president then uses that authority to conclude agreements, which then immediately become binding at the moment that the president or his representative signs off on it. So the Congress gives authority in advance, but then doesn't get a chance to see the actual agreement that's been concluded until it's already entered into effect. Now, these agreements are largely invisible in international law scholarship. People, if you look at an international law casebook, chances are they don't say a thing about them. The agreements are almost never discussed, and you certainly will hardly ever see anything about them in the press. And yet, just about 85% of our agreements are concluded this way. They operate in a vast array of areas, most common among them defense, trade, debts, postal matters, agriculture, atomic energy, economic cooperation, employment, investment, education, mapping. I mean, it's everything. There are hundreds of different areas in which you see these kinds of agreements. It would take 30 years of Article 2 treaties to match the number of ex-ante congressional executive agreements in a single year. Now, there are four key concerns that are raised by ex-ante congressional executive agreements. So again, it's no coincidence that ex-ante congressional executive agreements have entirely escaped notice by scholars, even international law scholars, even people who are experts in the field, because the process of concluding them is almost entirely hidden from view. There's no information provided to the public, there's no draft release, you wouldn't know that one is being negotiated until, again, 60 days after it's entered into effect. It then has to be disclosed to Congress, but actually there's nothing about when it has to be disclosed to the public. In fact, the main publication for publishing these was for a time running 10 years behind. And so when I started asking questions about this, I'm sure it was coincidental, but they started releasing the Case Act reports. These are the ones that go to Congress on the web. So now you can actually find out 3-month-old agreements in a way that you couldn't even 2 or 3 years ago. But still, you don't find out about them. Public doesn't find out about them until they're many years in the past, until they've entered into force, and there's really nothing you can do about them. And truthfully, the disclosure to Congress, it comes in this big binder, and it's like the lowest person on the totem pole in the Senate office is stuck having to flip through these. And there's not much reason for them to do much about it, because at that point, there isn't really much they could do. So Congress delegates open-ended authority, usually with no time limits. Congress gives this authority in advance to the president to negotiate these agreements. There's no time limits put on it. And then the president can negotiate these agreements forever. So there could be authority granted in 1960 that's still being used today. And so the Congress that gave away that authority isn't the same Congress whose authority is being used today. Third, there's literally no congressional oversight over the agreements that result. Congress can't reject the agreements other than, again, by passing a law that's inconsistent with it, which is, again, subject to a possible presidential veto. And there's no accountability or transparency. The Administrative Procedure Act, which governs similar kinds of domestic rulemaking and would otherwise probably cover these agreements, expressly exempts foreign affairs. So there's no transparency, no opportunity for notice or comment, and no opportunity for Congress to respond to agreements it doesn't like. The end result of all of this is that there are little or no checks on the president's unilateral lawmaking authority using this authority granted by Congress. Hence, government officials are not able to report one another's bad behavior to the electorate or preempt it through the exercise of their constitutional powers. And at the same time, there's no accountability to the American people. The public's kept entirely in the dark. As I mentioned, these agreements are not released until 60 days after they've entered into effect. And then they're only made available to Congress. There's no guarantee the public will actually even then learn about them. And once they're made public, there's no information about which agreements have been concluded under statutory authority, which ones under the president's own sole constitutional authority, which ones under other authority. So it's almost impossible to trace with any kind of precision where the grant of statutory authority came from. You just have to kind of guess at it. So ex-ante congressional executive agreements satisfy the form, but not the function of interbranch cooperation. And they're made entirely outside the view of the public and shielded from public scrutiny. Now, one might grant me everything I've just said. Yes, you might say Article 2 treaties, sole executive agreements, ex-ante congressional executive agreements don't really meet our usual standards of democratic accountability. But you might still wonder if there's really anything to worry about here. You might say, this is, after all, international law we're talking about. One might imagine this is an arcane area of law that influences diplomatic ties and border disputes, but doesn't really affect ordinary people's lives. But nothing could be further from the truth. More today than ever, international law and domestic law are converging. There's almost no area of domestic law that isn't affected by an international agreement. Agreements on intellectual property rights affect the rights we hold and ideas we produce in these halls. Food safety agreements are going to affect the safety of the foods you're going to be eating at dinner tonight. And it affects the cost of paper, computers, everything else that we use on a daily basis. The clothes we're wearing are affected by international agreements. So this can't be dismissed as a concern of international legal scholars alone. This is something that really does have a daily impact on people's lives. Now, the problem here is not simply that international law is made in ways that are insufficiently accountable and legitimate, but it's also the case, I think, that because international law is made in this way and it's viewed with suspicion and doubt, that's found its expression in scholarly rejection of international law altogether. and in the Supreme Court's decision in the recent case of Medellin v. Texas to refuse to give effect to some core international agreements. Indeed, courts for a long time have had a hard time figuring out what to make of international law, how to use them, and they've developed this kind of confusing doctrine of self-executing and non-self-executing treaties to try to make sense of this, which shrinks the effective role for international law at a steady pace. So here I'm going to turn to the second part of my talk. What do we do about this? What do we do about these shortcomings that I've just laid out? One possible response, and one that I think is misguided, is just to reject international law altogether. Right? One way to thing is to say, these are really not worth it. But I argue for another way forward through what I call normalization of international law. By normalization, what I mean is take international law within existing domestic political and legal structures as a way of strengthening accountability and legitimacy and ultimately effectiveness of international law. So I have three proposals about how to do that. Let me pause first, though, to say a few words about the fourth way the United States makes its international agreements. I told you there were four, and I told you about three. I told you what was wrong with those three. Now I'm going to tell you about the fourth, ex post congressional executive agreements. This is one I actually like. Now, ex post congressional executive agreements are agreements that are concluded by the president, and then after it's concluded by the president, it is approved by Congress. It's voted on by Congress. That's why the ex post, the vote by Congress, is coming after the agreement was negotiated. Ex post congressional executive agreements emerged after the defeat in the Senate of the Treaty of Versailles after World War I, a decision that, in the words of President Wilson, broke the heart of the world. In 1925, a House committee report concluded that it was proper to adhere to the Permanent International Court of Justice through an ex post congressional executive agreement. It was subsequently used to join the International Labor Organization, to establish U.S. participation in the International Monetary Fund. An ex post congressional executive agreement was used to join the World Bank, the Food and Agriculture Organization, UNESCO, and the World Health Organization. And it's used most often, as the NAFTA example suggests, in the area of trade. Indeed, ex post congressional executive agreements have become the method of choice for concluding trade agreements. In fact, there were just a few recently concluded. The Colombia, Peru, and South Korea agreements were recently concluded. Now, the reasons that ex post congressional executive agreements are used now prominently in trade are twofold. First, the process for concluding Article 2 treaties, as you've just heard, is really cumbersome. It's hard to get 67 senators to agree on anything. So trade agreements going through this process find that you don't have to cater to the ideological extremes. So increasingly, presidents have directed trade agreements to the ex post congressional executive agreement process because it simply works better. Second, like many international agreements, trade agreements require implementing legislation in order to become fully effective. You can't change a tariff schedule, for instance, through an Article 2 treaty. So concluding trade agreements as Article 2 treaties means going through two separate steps. You'd have to do an Article 2 treaty and then implementing legislation. But the ex post congressional executive agreement gives you one-stop shopping. You get it all in one package. But these arguments don't apply to trade alone. There's no reason that ex post congressional executive agreements have to be limited to trade. So my first proposal for normalizing international law is that the president could conclude more agreements as ex post congressional executive agreements and fewer agreements as Article 2 treaties. Now, as a matter of constitutional law, there's absolutely no reason why this can't be done. There is no constitutional law reason why that can't happen. Our current system, which tends to limit ex post congressional executive agreements to trade, is just a historical artifact. It just happens to have turned out that way, but there's no legal reason it had to be that way. So expanding our use of ex post congressional executive agreements would have three key benefits. First, it would allow the House to participate in the process and in concluding agreements. Second, it would allow the process to be streamlined. You don't have to go through this two-step process. You don't have to appeal to the extremes in the Senate. You just go and get a single package. Third, it results in more reliable commitments. Courts know what to do with legislation. They know how to read it. They know how to enforce it. They'd be more likely to do so. So the process could begin with the president just simply submitting more agreements as ex post congressional executive agreements. It's as simple as that. My second proposal is to facilitate these agreements by enacting broad-based fast-track legislation to streamline the procedures for congressional approval of international agreements. You probably have heard of fast track in the trade area. So Congress has repeatedly adopted legislation. We don't have it in effect right now, but it has in the past adopted legislation to streamline the process of approval of trade agreements that allows the president to negotiate a trade agreement and then submit it to Congress as a package. Congress agrees to not add any amendments and to get it through in a relatively quick period of time, to vote it out of committee within a certain period of time and then vote it to the floor within a certain period of time. And that's part of the reason this process has been so successful in the trade area. But there's absolutely no legal reason that fast track has to be limited to trade. It's just a modification of the House and Senate rules. That's all that it is, and that's the sort of thing that the House and Senate can do by itself. Expanding fast track would have many beneficial effects. It would make the process of gaining approval for international agreements from Congress a lot simpler. The provision for considering the agreement without adding amendments is especially important because it means the executive won't be caught in this endless loop of renegotiation, of getting it approved and then going to the other side and then re-amending it and changing it and going back and forth. And that's one of the reasons it works so well in the trade area, and it would work just as well in the area of the environment, for instance, or international tax. Third, and finally, I propose an Administrative Procedure Act for international law. So I mentioned to you this Administrative Procedure Act, which is familiar in law schools, maybe not so much outside of law schools. It's an act that was passed when the administrative state was getting going that provides for kind of more for oversight of administrative lawmaking. As I mentioned, the foreign affairs are entirely excluded from the Administrative Procedure Act. And so you don't have a process for notice and comment rulemaking in foreign affairs. You don't have something short of full-blown legislative process available in the international law area. So my proposal is that we try to design a process like that for congressional executive agreements. Frankly, it's impossible to have every single ex-ante congressional executive agreement that's made today pass through the full legislative process in Congress. There are over 300 a year. That's more than one a day that the Senate is in and the House are in session. That's just, there's no way that's going to actually happen, that you're going to have both houses vote through the full process. But you could have an APA process, much like you have for rulemaking, for administrative rulemaking, that allows for notice and comment, that allows the public to know when agreements are going to be made, that allows them to comment on them. And then if there's a problem, allows the public to raise that and bring it to Congress so that there can be a full-blown debate in Congress. Now this has three key advantages. It would improve transparency. It would just allow people to know what's going on. They would actually see the agreements before they went into effect. It would give an opportunity for public involvement. Right now, nobody knows about them, and so therefore it can't say anything about them. And so you have agreements being negotiated in areas where there are experts that are never have an opportunity to say anything about it. Those businesses and individuals who are affected by international agreements don't know that they're being negotiated, so can't provide any feedback to negotiators. It would also have the effect of making explicit what's now implicit, which is that these agreements are, in fact, many of them administrative in nature, and they should be treated that way. It also would affect their way in which courts would deal with them, which would be a good thing. I recognize, of course, that normalization of international law that I propose today doesn't assure perfect democratic accountability. We can point to all kinds of accountability problems in the domestic law process. In fact, we've all had a front row seat to the recent pathologies of this with the debt crisis and the healthcare debate, none of which seemed all that great. The democratic accountability and legitimacy of the political system sometimes does seem in doubt. My answer to this is that when you're on your own 10-yard line, the 50-yard line looks pretty darn good. So it may not be perfect, but it's a lot better than the process we've got right now for international law, which so completely excludes the public from the lawmaking process. So bringing international law within these bounds, within this normal domestic law process, has two central virtues. First, it would strengthen democratic accountability of international law, both internally through stronger intergovernmental authority and accountability, and externally through strengthened transparency and opportunity for public participation in the process. The difference between obtaining the approval of 50 or 60 senators and 67 senators is immense. And just even releasing the sole executive agreements and ex-ante congressional executive agreements before they go into effect and allowing the public to comment on them would really lead to significant effects on public accountability of these agreements, even if it doesn't get us all the way there. Second, the proposals promise to lead to more effective international law. The simple fact is that judges often don't know what to make of international law. They're uncertain of how to apply it and confused by the debate surrounding whether it can be applied directly as directly enforceable law and whether it requires implementing legislation. Is it self-executing or non-self-executing? They don't know how to make sense of this debate. Normalizing international law in the ways that I've suggested gets rid of that debate. It just presents them with agreements that look just like the kinds of law they're dealing with on a daily basis. It looks just like the kind of legislation they're seeing on a daily basis, the statutes or the administrative rulemaking. So it puts it in a familiar framework and allows judges to treat those rules in the same way that they treat domestic law. So today I've argued that we should hold international law to the same standards we hold the rest of our law. When we do, we can't help but see its shortcomings. Rather than abandon the project of international law, however, argue we must seek to redress these shortcomings. And I believe the way to start is through normalization of international law. By bringing international law within these familiar structures of democratic accountability, we can improve the democratic legitimacy of international law and its reliability. In the process, I think we can make it possible for the United States to more successfully meet the global challenges it faces as the new century begins. And I welcome your questions and comments and thoughts on the project.